All right, we are live. It's been a couple weeks since we were here. I have been traveling, including on a ship for a little bit of the last week and a half, and nobody took up for me while I was out of town. But this week we have Ari Sauer. Ari, look up and say hello.
Hello.
We're talking about this week's immigration news. I actually gave this live stream a name a couple weeks ago, and I don't think I just was calling it Siskind Susser live stream. Very creative. We started this, I guess, in January of last year. Now it's This Week in Immigration, which is also pretty generic, but I think it sort of tells what we do. And Ari was saying this was a slow week in immigration. What are we going to talk about? He was texting me that earlier today, and it's Ari. It's never a slow week in immigration. We just haven't things haven't percolated. We've just been so busy in our day to day that we haven't been paying as much attention. But all the craziness that happens in immigration now, we're so numb to it that we don't even think things are major news when they are. But we do have things.
Yes, it definitely hasn't been a slow week for us. It's just been a crazy week for us, and for most immigration attorneys do employment based.
Yeah, once we started talking, we found a bunch of stories that we're going to cover tonight. So Ari, what you are the moderator, the determiner of what we're talking about and in what order. So what do you want to talk about first?
I'll tell you, why don't you start us off with there was an interesting case about the BIA in the federal courts.
Oh, yes. So the BIA, some of you may know that a few weeks ago, sometime in February, actually, but it's been a bit, that they issued this really extreme new regulation. And basically this new rule hit a lot of it basically turned the BIA into a rubber stamp so that the people that are filing appeals with the Board of Immigration Appeals, that's what the BIA stands for, really had no hope in terms of the changes that and so there were a lot of things that this rule did. Among other things, probably there were a couple of really serious things. One is that it cut the time that you had to appeal from 30 days down to 10 days, which is like no time to get an appeal together. Another thing that it did is it basically essentially ordered judges to that they could deny appeals without actually hearing the facts and hearing arguments. Which would, apparently hit about 90% of the appeals would potentially be blocked. Well, as is with most things in immigration that are really ridiculous that are happening, somebody filed a lawsuit. There was the Amica Center for Immigrant Rights versus EOIR, and happily there was a ruling in a federal district court about a week and a half ago. So it's really this week and a half in immigration. Since we weren't here last week, we couldn't tell you guys about it. But basically, a federal court blocked key parts of the new immigration rule from the BIA, blocked them that were scheduled to take effect on March 9th on there. So it was just in the nick of time. Anyway, it wasn't all parts of the rule, but it was most of the really controversial ones. And for now, the BIA is still a thing. So that's a key part of due process that remains available to immigrants. Now, not that the BIA isn't denying a lot of the cases that it's hearing, but it's at least it's still available. So that was a nice court win. There are other court wins this week that we'll be talking about, but that was one of them.
All right. So one of the biggest news this week, at least I think, is the visa bulletin came out. April 2026 visa bulletin came out, and there's some interesting changes this month. especially after last month where there was very little movement in the visa bulletin. So first thing is the USCIS has, for their I-45 filing chart, has said that we can use the final action, the dates for filing chart for both employment-based and family-based, which is always good news. That gives us a better chance to be able to file applications. And just to explain to those that are newer listening to this, the dates, the difference between the two charts is the dates for filing, when we can use it, is the dates that we are allowed to file the application. But that is not when a visa is available. That's not when USCIS or Department of State is able to either approve the green card application or issue the visa. That goes by the final action dates. So in family-based categories, we had some in the worldwide categories. We had some good movement.
I'm playing around with Claude while we're talking because it's I've been enjoying using it for. It's really nice at making pretty charts on there. So you'll see if it's. We'll see if it's how it does with this particular task. But you can see what I did on this one, where I asked it to for rest of. I mean for the both family and employment based. And by the way, I didn't tell it to set it up this way. It was just smart enough to do it. But this is the comparing the latest visa bulletin. I hope the numbers are right. I think they are, to last month's bulletin and to a year ago. And then this column where it says mom is month on month, and where it says yoy, it's year on year. And so you can see some significant movement for certain categories that were happy news, particularly like India EB2, which had 10 months in the final action dates. Hopefully Claude got that right. If it didn't, we should all
the final action dates.
Blame Claude, not me, for this.
I did my math the old-fashioned way. So EB2 India.
All right, I'm getting a message that's not
not right.
All right, sorry about that. It's not right.
No, well, we'll go back up. EB2 India final action dates moved
from January to February to September. Did it not do that?
Hold on.
Oh, that was over a year.
Okay,
over a month.
It moved 2 months.
Where was it in March? All right, never mind. Claude is terrible.
Let me say, okay, EB2.
This is
final action dates for EB2 India went from September 2013 to, it is, I don't know what, 2 months. From September of 2013 to July of 2014. So,
but it is right here.
December.
That's 10 months.
Oh, like I said, okay, it is 10 months. Right.
All right. Claude for the win.
Yeah.
And it did did it also for family sponsored as well, where we had some nice movements as well.
Which the really important part about that is that this is the first time in a while that the EB2 India has overtaken EB3 in visa availability.
Yeah.
So
it's still working on my little chart for the filing. I asked to do a chart base for the filing dates. Are they doing filing? Or are they doing filing dates or just final action dates?
They're doing filing dates this month. Yeah, it's dates for filing chart this month.
All right.
And the big news there is third preference worldwide is now current in the dates for filing chart. So that means a lot of people in the EB3 category are now able to file their I-45s. Also, some forward movement on the EB3 India. So now EB3 India and EB2 India for the dates for filing are now both at January of 2015. So they're
it's important to note also that what the filing date chart means. That's what they think the final action dates will be next September. That's a prediction by the State Department on where they think final action dates will be at the end of the fiscal year. And that's how they come up with the filing dates. So the filing dates usually, once they set them, it's unusual for them to change them this time of year because they usually set them when the fiscal year opens up. However,
our guess is
they might be getting fewer applications than they were anticipating, and they're just adjusting the dates because the predictions were wrong at the beginning of the year.
Well, I think also it might have to do with the the visa bars and USCIS pauses.
Fewer coming in, fewer getting
that are I mean, less cases getting adjudicated, so they're trying to get more cases in so that they can adjudicate those cases that they are allowed to.
Okay. Well,
that's my guess as to why we're seeing this kind of movement here.
It's really good news for people that are in a position to adjust. Now, with that said, the warning I give to people is if you file your adjustment application, do not let your non-immigrant status lapse.
It's especially important now.
It used to not be
more than ever.
It used to not be a big deal because you had you were arguably in status if you filed your adjustment application. Now they're taking the position.
Well, sorry, I'm just going to correct you. You weren't in status from the adjustment. You were in an authorized period of stay, and that's the difference.
Right. Essentially, yeah. They viewed you in status.
Correct.
I'm not speaking in the
right. But, we are attorneys, so I'm going to correctly give the
terminology. But you were in a legal state.
Right.
You're
authorized period of stay, you're allowed to be here.
Right.
Yeah.
So that has never been formally changed. I'm just telling you that we are hearing examples of people that are filed adjustment applications properly that have been arrested at their interviews because they didn't have an underlying status. Right. Which
now it's not across the board. So I don't want to cause too much panic, but there are cases, and especially in certain places more than others.
If that chart eventually finishes, I'll put it back up. But that's the warning: is that keep your underlying non-immigrant status valid while you're filing for adjustment of status up until you have your green card. Try and keep a non-immigrant status in hand. And we'll see. I have a feeling that will be challenged, and we might get some federal litigation out of that where the courts will say you can't do that without rulemaking. But that's where we are on that. All right, Ari.
And also, some additional interesting occurrences in the visa bulletin this month. F2A is now current across the board in the dates for filing, which means that now if you have a green card holder spouse or parent, if you're under 21 and unmarried and have a green card holder parent, or if you have a green card holder spouse, that's the F2A category. They are now you're able to file your application for adjustment of status together with the I-130, which hasn't been the case for a little while there.
Yeah, no, it's amidst a lot of bad news, especially in employment and immigration, it's good to be getting some of this news. So if your, if your dates have changed, you can't file anything until the first day of the month. You should start getting ready. Hopefully your lawyers are reaching out to you, and you guys can, some of you can start proceeding with adjustment applications.
Okay. Greg, we gotten some questions about the H-1B $100,000 fee lawsuits.
Yeah, so I can give an update on that. So there are 3 suits, 2 of which have had oral arguments at this point, one of which has had both a district court and the appellate court. That's the Chambers case in Washington, D.C. And I think we did talk about that in a past broadcast. But the Chambers, they got a pretty unfriendly audience at the district court from Judge Hale, and I think people were kind of down. They did a really nice job with their appellate briefs, and during the oral arguments at the appellate level, which happened a couple weeks ago, I think the overall consensus for the folks that were listening and the people that read the transcripts were that the chamber did a good job arguing, or their lawyers did a good job arguing, and they got a big favor from the Supreme Court, which has ruled on tariffs that the president can't unilaterally impose taxes, which is essentially what they ruled in the tariffs case. So that is, and in the California case, which our firm is co-counsel on, that's the Global Nurse Force case. The arguments happened on that case about 2 weeks ago, or a week and a half ago. But anyway, in that case, we also were pretty pleased with the way the arguments went. The judge, this particular judge in California, he asked tough questions, and he asked for some supplemental briefings. One on the Supreme Court case, the research. I forget what the name of that case. It has a very generic, weird name for this case. Research Center. I forget what it is called, but and we've already submitted our basically he wants to take from both the DOJ lawyers and our lawyers about how we think that case impacts our litigation. Obviously, we think it helps the H-1B case. There was another case that didn't go so well on refugee processing called Pasito, and in that case, basically, that was the Ninth Circuit, which is, of course, the circuit that is over the San Francisco court hearing our case. And in the Pasito case, the judges in that appellate case said that the president could stop basically all processing related to refugees, and not just barring the entry of refugees, which is contrary to what a lot of the case law has said about these travel bans. So that wasn't particularly helpful to our case, but we think there were a lot of ways to distinguish it. And the judge asked us to also brief that and explain why we think it's relevant or not relevant to our case. And we've done that, and that was submitted earlier this week. So we probably will get a decision fairly soon in that case, but that's where we are right now. Now, there's a third case that was filed by the 17 states attorneys general, and that's going a little bit slower. I think they have arguments maybe on March, like next week, maybe. I think it's coming up pretty soon, and that's in Boston. So I wouldn't sleep on the state attorneys general. They have a lot of resources, and they typically don't sue on things that they don't think they have a good shot on. So we will see on that. There's a related, so that's the news basically on that. Now, what I can tell you is that there are some rumors that a couple of doctors got national interest exceptions for waivers of the travel ban in the last couple of days. That would be the first cases that we've heard about since the H-1B ban. The $100,000 ban came into effect last September. So we will be on the lookout for more on that. And we will see if that's a trend or not. And, Ari, we're going to talk in a minute about the H-1B lottery. Before we get to that, there was a related question from about whether this exemption for the fee, legislation to exempt doctors from the $100,000 fee. Honestly, I don't. Even the most popular immigration bills that the pro-immigration bills don't seem to go anywhere. But the administration actually promised an exemption for doctors about a week after the proclamation came out. Steve Witkoff, the president's commerce secretary, Iran negotiator, and about 18 other hats that this guy wears. I don't know how he was involved in this issue, but he said that they were going to have an exemption for healthcare, and that never happened. And that's obviously a lot easier for them to do than legislation. So I'm not holding my breath on Congress, and I'm not holding my breath on the administration, because Stephen Miller doesn't like, never met an immigrant he likes. And I don't think it matters whether they're a doctor or an aerospace scientist or whatever they are. He thinks they all should be gone. So it's not a surprise that, we're 6 months in on this, and we're seeing the first national interest exemptions for a couple of doctors. And I'm not even sure that's true. That's just a kind of a rumor in the immigration bar. So the answer, I am not super optimistic, but I've been wrong before, so we'll see. I've been wrong many times, actually, not just once or twice, but many, many times. So we'll see on that. Okay, and then there's a question about the F1 visa revocation case, where the possibility of plaintiffs getting their visas reinstated. So we're working on one of those cases. There's more than one. Our case is in Boston, and we think we have a strong case. What do I think the possibilities are? I think the possibilities are good on there. We have a lot of good case law, some of which I was co-counsel on a bunch of those COVID travel ban cases, where we got court decisions forcing visas to be issued, even though there was still a ban on entry to the United States. And so we will see on that. But I'm cautiously optimistic, and you always have to be cautious because you never know. All right, what do we got? What else do we have?
All right. Well, there's been some update to the visa bond pilot program. So for those of you that don't know, this is regarding visitor visas from certain countries. There have been 12 new countries added to this list, so there's now a total of 50 countries that are going to be subject to this, and this is going into effect April 2nd.
Tell us what this is. Like, what is this bond?
Okay, so basically they are creating a limit on visitor visas issued from these to nationals of these countries that would require a bond to be paid of either $10,000, that's the standard, but in some cases it'll be $5,000, in some cases it'll be $15,000, that will need to be paid by the visa applicant before they're issued the visa. It also limits the visa to a one-time use visa instead of the multiple use visas. And it'll be visas valid for 90 days and only grants the person an entry for up to 30 days.
So let me sort of just say,
no change of status.
So the way I'm not a criminal lawyer, and neither are you, but the way my understanding is, the way it works in criminal law for bonds is you have to put up like about 10% of the bond amount. And so when you're talking about a $10,000 bond or a $15,000 bond, it means you probably have to come up with about $1,000 for the bond. And then they, if you abscond with it, they'll obviously come after you. But that's what they would charge you probably for somebody putting up that amount of money for you, if there's a bond company.
If there are bond companies that are willing to do it.
It's like a business. I mean, it's like, I hate to say it, but I think there's a business opportunity for somebody out there. If you can figure out how to do if you want to like do your risk assessments and be able to set it up. I certainly have no idea how to set up a bond company. But that's that. We're also there's a question as well about the Georgia case. So I will address that, because that's also our case. And that was argued today. And I have been on a text chain back and forth with Zach New from Joseph and Hall in Denver, and Chuck Cook from Cook Baxter in Atlanta, are the two lawyers that argued the case in the courthouse today in Atlanta. And this one is the pause on USCIS benefits for people from the 39 countries that were part of that travel ban. And it went well from all indications. The judge asked hard questions about the impact of the ban. He was wanting more information about whether we've had final agency action, which is an administrative law an important concept, and whether you can challenge the agency if they've actually, you have to, in order to appeal something, or you have to show in the Administrative Procedures Act that the agency has either formally made a decision not to act, or has taken a very unreasonable amount of time. And they call this a temporary pause, but it doesn't. There's no indications that they are ever going to do anything about it. There was some news in the case today that this may be the first time people are hearing about it, but the lawyer for the Department of Justice, the lawyer for USCIS, essentially said that they would have some news on this by April 1st. And so we think the judge may not make a decision before April 1st while he waits to see what happens. I'm not sure that I think if the lawyer doesn't come through with something showing that some important change happened before April 1st, the judge is going to be kind of irritated. So it's probably the government. So I wouldn't imagine something like that would have been said if there was just a complete bluff. So we will see. I have no idea what's going to be in that announcement. We didn't get any indication about what it was going to be, but the lawyer asked the judge to hang on issuing a decision in favor of us until that's released. So who knows? Maybe we're not the only case that's been filed in this space, and there actually have been some wins already in other courts, and there are several that are due right now for decisions. So we could, I think it could be that, like the student visa, the CVIS revocations that happened last year, Ari, when all of a sudden there were sort of a slew of wins for the plaintiffs around the country, that the government caved, and we could see that happening here, where they see that this is a loser for them, and they're going to look that they may just announce that they have changed their security processes or whatever that they were claiming that they were going to be doing, and they are resuming processing. And that would be our case being mooted out because the government basically surrendered is perfectly fine with us. We don't have to have a sort of a win on the record if we get what we want through other means. So we'll see if that actually happens.
All right. And updates. There's a question on updates on the 75 country case. When we filed, it's already filed, correct?
That one, I don't have I can look and see, but I don't think I have an update on that one. I do have an update on another one for DV. So basically the State Department stopped processing on DV winners, regardless of the country bans. That's a separate issue, but they just stopped work on diversity visa, immigrant visa processing at consulates. And that's one of the cases that we filed recently. But there's another case that we started onboarding this afternoon, which is diversity visa selectees who are filing for adjustment of status, because USCIS has also stopped working on adjustment of status applications for diversity visa winners. And of course, in both the case of visa processing at a consulate and adjusting status in the US, you have to finish processing by September 30th or you lose out on the benefit. So it's really critical that they keep those cases moving.
Yeah, it's especially egregious that they're doing that with the DB lottery.
Yeah, so if you're in one of those situations, and you should consider our litigation if you want to participate. Because one of the things we have found on these cases is, even though we ask for the policy to just be completely enjoined and shut down, sometimes it's just our plaintiffs that get the benefit. That happened over and over again when we sued on travel bans for fiancé visas, where we would ask the judges to basically make a ruling that they couldn't do visa bans, and all we would get was an order from the judges saying the plaintiffs get their visas, and we didn't get universal relief, even though we were trying to get that. So anyway, that's the news on diversity visa litigation, and the 75 country ban. I'm looking at it. We may, I don't know if we're still onboarding on that case. I'm just looking at it right now on here. I have to ask John. That's one I haven't been working that closely on, so I don't know, but it's one of our cases too. But it may be filed already. So I apologize. Don't rely on anything I'm telling you.
I think it has been filed. That was my understanding, but again,
while I was on vacation.
You're wrong.
By the way, I got this chart to work finally. So this is the filing dates, Ari, not the final action dates. The dates of filing. So the dates of filing. This is family. Let me go back.
Yeah, family. And again, as you see, F2A current, which is very important.
Yeah. So here we are on it. So some of them stayed where they are for filing date charts, but we did see some important advancements. EB3 rest of world current. We saw a 2-month jump for India. Is this? Yeah. India EB2 the filing date charts, a 5-month jump for EB3 India in the filing date charts, and a 1 month for rest of world jump. So those are some nice changes that we saw in the chart this month. And you can also see,
right. And also, even though EB4, even though there was no movement on the filing chart, the final action date chart moved up a year. So that's going to be extremely helpful for those EB4 applicants.
Back up on here, EB4, 1 year. A 1 year advancement went from unavailable a year ago, in April of last year, to now being July 2022. So that is that's very nice for that group.
I wonder if that's at all related to the change in rule for the religious workers. They created a situation to allow for extensions beyond 5 years with the.
I don't see how that changes the visa bulletin, though, unless they are changing, the. Well, I don't think. I mean, I guess there's was a big drop in the number of EB4 applications that were filed.
For sure, there was a significant drop when they moved those numbers back. A lot of those that would have used the EB4 category then were using the EB2 and EB3 categories.
Yeah, but isn't this cool what this AI did?
Yeah.
Just say I'm not pushing Claude, but boy, it's just such a nice output. I use it now for PowerPoint slides and for charts and all kinds of things like that.
What did you do before AI? What'd you do for fun before AI came into play?
I used to remember the Siskind summaries.
Yeah.
I used to take 2 days off of work to basically analyze a piece of legislation and do one of those crazy 75-page summaries or whatever that I would push out.
And now you just do it for fun.
All right. All right. So we are at 7:36. We've only covered a handful of things. Keep us going.
All right. Well, we covered a whole bunch of things, but all right. Do you want to talk about in more local news, Tennessee legislature?
Yeah, it's really crazy that we're making national news. Well, we make national news for stupid reasons here in our state frequently. This one's pretty upsetting. So our state legislature, the House, Tennessee House, passed a bill yesterday. I think it was yesterday. That requires public schools, and I have a daughter who's a school teacher, so I'm sure she's going to be thrilled with this, to check the immigration status of their students. And that is, they say they're, and this comes the same day that Tom Homan sent a notice to the the head of ICE sent a notice to the Congress. He sent a letter out to all of them saying they were not going to be doing enforcement activities at schools anymore or at hospitals. So, which is nice. And then our legislature basically, says that they're going to collect this information, not to deport, but they just want to like have the information on there. But there's this case called Plyler v. Doe from 1982 from the U.S. Supreme Court that says all children are guaranteed access to a K through 12, that's kindergarten through 12th grade education, regardless of their immigration status. So that's a Supreme Court case. And this is blatantly unconstitutional what our legislature has done. So why would they pass something that they know that as soon as it gets to a federal district court judge, the judge is going to say, my hands are tied. Plyler is pretty clear. This is unconstitutional. Why would they do that? Because the same reason that the Roe v. Wade case was challenged, that the Roe v. Wade was the 1973 case that guaranteed access to abortions in the United States. The state of Mississippi passed a law that was pretty blatantly unconstitutional under Roe v. Wade, hoping that case would make its way to the U.S. Supreme Court and that they would reverse Roe v. Wade. And that is what is happening with Plyler v. Doe. So even though this is Tennessee, this is our legislature hoping to get the U.S. Supreme Court to convince them to change to throw out Plyler and bar children without status from having access to a public school education. So it's pretty serious stuff. Hasn't passed been signed by the governor yet. It hasn't been passed the Senate, the House, and the Senate. But we're a pretty pro-Trump, legislature, pro-Trump governor. And I see this as being something that's very likely to become the law. The day the governor signs that law, there will be a lawsuit that's probably filed within 24 hours. And then we will have to see what the federal district court does about it. But I would think it's almost a sure bet guarantee that court's going to say, even if it's a Trump appointed judge, they're going to say, well, our hands are tied by Plyler, and it's going to have to be the U.S. Supreme Court either saying, we're not taking this case and that's the end of the discussion, or if they take the case, then I'd be pretty nervous. But, they took the case on the other one that's sort of like a pretty blatant, unconstitutional, is the birthright citizenship stuff that happened. And that's a similar play where the Trump administration, they issued an executive order on something they knew was surely unconstitutional under the case law. And they're hoping that they get the Supreme Court to reverse. So it's a similar playbook to that as well.
All right. So there's been a lot of movement or a lot of action by the administration regarding TPS, temporary protected status, for various countries. Yeah. This week, there's been some news regarding Somalia's TPS.
Well, there was bigger news a couple of days ago from the U.S. Supreme Court. Actually, Ari, that case was on Monday. We thought it was last week. It's this week. So that was on Monday that the Supreme Court issued its decision. But that decision was relating to what we're going to be talking about at the district court level. So why don't you say first what happened at the district courts, and then I'll talk about what the Supreme Court said.
So, okay, I thought you were talking about the district court.
Oh, well, I can. So we had we had two different district courts make So on Somalia, a district court in Boston issued an order staying the termination of the TPS program for Somalia. And then we had, I thought there was a second one. Maybe there isn't a second one. No, I think it was just that one. But the bigger news was the Supreme Court, which I'm looking for that case right now. Where'd it go? So on Monday, the court issued an order that the Trump administration was trying to get the court to do what they've been doing many times since he came into office, which is the so-called shadow docket. And the shadow docket is where the Supreme Court will issue a decision to either to stay or to temporarily approve basically to overturn an injunction on action that a district court has taken and allow a policy to continue. And there have been many things that the Supreme Court has allowed the Trump administration to proceed with. Courts at the early stages of a trial. So a lawsuit will be filed. A judge will issue an injunction saying this is going to stop. But it might be, 6, 8, 10 months later before there's actually a formal trial on the issue. And what the Supreme Court was saying, it's like, we're going to leave we're going to leave things, favoring the policy while we're waiting on the court. So it's usually a big win for the administration when they get these shadow docket decisions. So in this case, Supreme Court has agreed to hear. There have been 2 court cases blocking the end of TPS for Syria and for Haiti. Syria, there's 66,000 Syrians, and Haiti, there's 350,000. So it's obviously the Haitian group that's much bigger. And the Supreme Court, so that was a win for the administration. The Supreme Court's taking up that case where these, judges blocked it. But the big loss for the administration was they said, we are going to allow the blocks on TPS to stay in place until the Supreme Court actually hears arguments. They may not hear arguments until late in 2026. And they might not issue a decision on those cases until like June of next year. So we could see now a 15-month pause essentially on overturning. The administration may have to wait a full 15 months before they can actually, and that assumes that they're going to win at the Supreme Court. They may not. I think there's this common misconception that the administration has total control over TPS and that they can, they have a lot of latitude to announce the countries in TPS, and they have they can basically take it away with the same amount of discretion. And that's actually not what the courts are saying. Courts are saying you have a lot more latitude to announce you're granting TPS, but if you take it away, you have to show that you went through an adequate process and that it was not arbitrary, that it was not done with animus, and that and in these cases, these countries have travel advisories or serious warnings for Americans not to go to these countries, which is a pretty good indicator that things are pretty dicey. So the administration in all of these cases of the revocations didn't present any documentation or even bother to make arguments that things were safe in these countries for people to go back to. So we'll see what the Supreme Court has to say, but they're not going to be hearing these arguments probably until the fall, and they're not going to probably issue decisions until the end of the next term, it's always first Monday in October. When they hear the first cases, they will hear cases all the way up until May or so, and then they start issuing the rest of their decisions in June and sometimes up to early July. And this would be what they would call a blockbuster decision. So it would probably be, they usually hold those until the end. So we're probably not going to see a decision on this until summer 2027.
Okay. All right. Well, I saved H-1Bs for last, but before we go to H-1Bs, were there any other subjects? I think I have everything covered. Anything we didn't cover?
I don't think so. I was going to mention something about this Dignity Act. So there is this, there's a few more co-sponsors on this bill that is bipartisan called the Dignity Act. I'm putting this on your radar. I'm not holding my breath, but if there was ever an interest with President Trump making a deal, since he loves deals, this bill is a pretty interesting big trade-off, and essentially it would be mandatory e-verify across the country, which is something the Democrats have been blocking and Republicans want, as well as making asylum status harder to get, which obviously is not going to make people like me happy. But in exchange, they would grant a legal status to, I don't know, 10, 14 million people, but most of the undocumented population that do not have criminal records would be eligible for it. So this is very much, pie in the sky, but that was in the news. Ari, the other one I wanted to mention was the Senate Democrats who signed who basically are upset about DACA renewals. So we talked about that. I'm going to mention something about that. So this is in this case you have where are my notes on that? So Senate Democrats have been they sent this letter Tuesday or Monday rather it was St. Patrick's Day when on there to Kristi Noem and who's still the DHS secretary till the end of the month. And then Joseph Edlow, who's the USCIS director, basically demanding to know what is happening with DACA renewals that have been slow walked, where they have only been approving them with a very slow speed. And the reason why that is particularly serious, I was just reading the press release from Elise Slotkin, whose office I think originated this, but she had this terrible statistic on here that as many as 270 DACA recipients have been detained and 174 have been deported who have filed their applications in a timely manner for renewal. These aren't people who are like out of status. These aren't people who forgot. These are people who did everything correctly, yet 174 of them have actually already been deported from the U.S., even though they are in DACA and timely filed their renewal. So they sent this letter asking a lot of questions. I know I'm going to be paying attention to whether how USCIS and DHS respond to this, but that is really shocking, and it takes a lot to shock. We were talking about this before. That is just, I don't know what kind of evil they have going on there, but these are people who are been in the, have no ties to the countries. They have been abiding by this program usually since 2012, so 14 years they've been in DACA status. They filed everything correctly for renewal, and then they find themselves on an airplane shipped out anyway. So hopefully we'll get some news of a response to this from the agency saying they're investigating and this is stopping, and DACA renewals are moving along faster. But the fact that, and this was signed by almost every Democrat in the Senate. I don't know if it's all of them, but it seems like it's most of them. So we'll see how that goes. So Ari, we can now switch to the.
Well, we got another question saying, would it be fair to say that they would prefer physician jobs to go unfilled rather than an immigrant fill them? Well, I mean, considering that 25% of all physicians are former medical graduates, is that what it is?
Yeah. So I mean, I don't think you're wrong. I think there are some people that think that way. I think Stephen Miller thinks that way, that it would be, he thinks that you should, that an American should be doing it, even though every single American doctor is, they're not picking up the Sunday newspapers. I don't know if anybody does that anymore, but looking for jobs. Every doctor in America can find a job.
Of course, they had people look in the Sunday newspaper. We know because we advertise perm applications in there every day, every week.
Very modern process they have.
So, obviously people are looking there. Otherwise, the government wouldn't have us do it.
But the question, just to respond to your question, is that it's not that I think that they, to get back to it, that they would prefer that they go unfilled rather than. I think they just don't think about doctors. I think they just don't really care about the situation. They care about keeping immigrants out, period. And, they would call that collateral damage, but they would say overall the mission is to keep immigrants out. And we're sorry that that's happened, but they would say that the country will adjust. Will somehow figure out to find more doctors pull out of thin air.
And I've heard them say, well, if we don't, if we have a need, there will be more schools that'll open up to fill the need.
Yeah, by the way, I've done a lot of lobbying over the years on physician immigration, and there's a if a state legislature made the decision today, and Congress made the decision to make sure that there were enough residency slots, if they made the decision today that they want to open up a medical school or just even expand the number of students that can be graduating from medical school, it takes about 15 years before that, from that decision until from the doctors that are new into the system as a result of that decision actually start treating patients. 15 years is what we're talking about. So all these people that think you can snap your fingers and solve this problem, I always say to them, go do whatever you need to do. And when you've solved the physician shortage with American doctors, let's have that conversation. But I don't, I tell them, I said, nobody's serious about it, addressing it. It's a convenient talking point to say we should just have more Americans graduating, but nobody actually wants to spend the money to do it. It's very expensive. The tuition that you're talking about for each medical student is about, probably about $100,000 a year. Somebody's got to pay that. You have to pay for all the infrastructure. I mean, it's just a very hard thing to do, and that's that's not happening. There has been a little bit of an increase in medical school graduates, not enough to deal with the increases in population, not enough to deal with the increasing portion of the population that's elderly. It's certainly not enough to deal with the rural healthcare shortage.
Right, rural healthcare shortage, exactly. Not only in order to fill the rural healthcare shortage, not only you have to have enough doctors, you have to have a surplus of doctors that doctors would then be going to areas that they, might not otherwise want to live in.
Yeah, I've been doing 35 years. I have been doing physician immigration, and that's that's my biggest practice area over my career. And every year we've, since the beginning, we've been making the same arguments about these doctors are filling jobs that they can't, there's not enough Americans to do it. And we always have the pushback. It's like, well, we should just get more American. And my response has been the same the entire time. Do it.
Yeah.
Get more Americans to do what you need to do to increase the supply of American doctors. Do it on there. And and then we can have that conversation that it's, we don't need so many foreign doctors when we have plenty of US doctors. And it just has gotten worse and worse and worse over the last 35 years.
It really is amazing.
That's my rant, but Ari, we still haven't dealt with the number one story.
All right. So number one story, at least the number one story for me, because this is what we've been dealing with a lot this past week and a half or 2 weeks. H-1B lottery. So
yes. Tomorrow
is the end of the lottery period. And to be clear, very important you understand this if you haven't filed yet, if you want to file and you haven't filed yet, the end of the period is not the end of business day. It's not midnight. It is noon Eastern time tomorrow. So tomorrow, the 19th.
8 a.m. or no, 9 a.m. on the West Coast.
Right. Well, and just to be clear, that's when it ends. So you actually have to get it. It's 11:59.
You need to be doing this tonight.
Is things. So yeah, if you haven't done it, get it done tonight, especially if you're dealing with it tomorrow.
Why are you listening to this podcast, people?
There's going to be we expect that there will be glitches tomorrow morning. Everybody who has the last minute. So
the immigration lawyer audience, because I know a lot of immigration lawyers watch this too, not just immigrant folks. We probably have a lighter audience tonight with the immigration bar than we usually do because of the craziness with getting. On the other hand, well, I mean, there might be a drop in demand this is the year to file, I think, because of the $100,000 fee obviously took a lot of people out of the running.
Right.
We still have all the Fs and the Js and the other category, the that can file for a change in the United States, as well as people who are in cap exempt that want to switch to cap sub. I mean, there's still a lot of people that want to file. Last year we had 400,000, and that was a big downward trend because we had that change last year where it made it a beneficiary lottery instead of an employer lottery, which is also that, by the way, was the result of litigation that we worked on. That the
just to explain that for those that are listening, that the change was, it used to be that you could have multiple employers file for a single beneficiary.
It was a way to game the system.
It is now done by beneficiary. So
yeah, so there was a big drop in applications from like 700,000 to 400,000. So last year there was already a substantial improvement in your odds. My guess is we will see a drop by half. I'm guessing we have fewer than 200,000 applications this year. What do you think? Let's make predictions.
Yeah, I'd say that's probably fair.
This is the year. If you don't have to pay that stupid, even if you have to pay the $100,000 fee, I would still enter the lottery on the bet that the courts are going to throw this thing out.
That's true.
And there's one other. I hope nobody from the administration is listening to this. But I believe they do. But probably they are, and they just don't. Yeah. Believe me, they don't care what we say. But this is the trade. There's sort of a loophole. So at least now, the administration is going to have to do something about it. But
don't tell them.
They're going to. So we're going to find our new winners in a couple weeks, and you're going to start having applications filed for October 1st start dates.
Right. So just to give you the timeline, so the end of the lottery is tomorrow, 11:59 Eastern time. Tomorrow, March 19th. The drawing will be very soon after that. Could be the same day. Could be tomorrow evening. Could be. But it'll be soon by the end of March.
Right. Okay. So we get these
the lottery,
and they can file after April 1st for October 1st start dates. Not everybody. They sort of time it out how you can file it, but
right. So between April 1st and June 30th, those that are chosen lottery, that's where you have.
The proclamation only affects people who are asking for start dates before September 21st. So you can file that H-1B for an October 1st start date unless the administration renews the proclamation.
Oh, I got what you're saying. Okay.
They probably will.
They probably will.
But they're a little distracted right now with foreign policy and other things and new DHS secretary. Who knows?
The president just told them.
I just told them. I'm pretty sure they can figure that out for themselves. But if they don't get around to that, or they just decide, and by the way, we also found out somebody asked about our case. It was revealed by DOJ in our case that only 70 employers in the entire country have paid the $100,000 fee. That's it. It is not. So they're not raising any money here. And all those employers out there who thought we were going to get, they're going to get everybody in, they didn't file on there. I think so that's so maybe the administration would like a soft landing on this, but all I can tell people is it doesn't cost very much to file for the lottery.
$215.
Right. And if you get selected, you might, either you could win with the court, or you could file these cases before and maybe the administration won't get around to making the new, extending the proclamation until, May or whenever on there. And so if you get your application in before that, the odds are likely that they won't apply it to the people who already filed before the proclamation is issued. That's the way it was done the last time. So they are going to have to extend that proclamation in the next couple of days, or they're surely going to have some applications filed before they do that. And those people are going to have a pretty good argument to make that that they shouldn't have to pay the fee. So that's my little loophole that to pay attention to if you are in the situation where you might have to pay the $100,000 fee, but you get selected in the lottery. If you really hurry and file that application quickly, and the administration doesn't get around to doing the new announcement, then it's very possible that you can avoid the fee that way.
Okay.
And that was it in Ari. We're going to see fewer applications this year because of the wage rule.
Because of the wage lotteries.
Nobody sued on that issue. Oh no, that's not true. There was a lawsuit that was filed by I think Stevie Allaire was involved with that, but it wasn't in time to stop anything. I think there's a lawsuit on that. I'm not involved with that.
I mean, the problem with it is that you have certain occupations that are just, physicians come to mind, that are just the level one wage is the whole profession is a higher level wage. So someone who's getting paid a much higher wage than most level 4 wages is a level 1 or level 2 in that occupation or in some certain other occupations.
Oh, the doctors are always forgotten.
Yeah.
They should start every one of these rules always with doctors accepted, because that's a perfect example. There's only one wage for doctors in lots of parts of the country. So they are counted as level 1, and they get ranked lower in the lottery than people that might be making half their wage, because they're paid level 4 in a different occupation. It is not based on the need for people. It is based strictly on how much they're being paid, and that's not always a good indicator of which immigrants we need. So and those doctors may be paid the equivalent of level 4 if they actually are level 4.
And I realize, just for those that aren't familiar, the way it works, and this is a brand new rule, just this year created, is that based on, so for their prevailing wages, Department of Labor issues for most jobs in most locations. And there are 4 levels. It's split up into 4 levels, the prevailing wage. And this year, they've changed the rules so that if you are a level 1, you have, if the wage that you're being offered it reaches the level 1 level, then you get 1 ticket in the lottery. If you're level 2, you get 2 tickets. Level 3, you get 3 tickets. Level 4, you get 4 tickets.
Yeah, I mean,
the more you're being paid, potentially, the more
right. There's some,
you have in the lottery.
Right. You can make some arguments that there's some good policy reasons to do that, but it's still not very thoughtful, because it's using a very it's better probably than having complete randomness. But it's not a very smart way to run a high skilled worker program. I could come up with a much better program if somebody wanted to pay me to be consult on that and design something. I could design something a lot better. Anyway, but that's another reason why the odds are better this year, because I think a lot of people didn't file that saw they only had 1 entry. So anyway, all right, what was your guess? We're on the record. 200,000 for me. What's your guess?
I think that's a good guess. Should I do the game show and do 201,000? No,
201.
201. Right, exactly.
That's the price.
No, I mean, yeah, I think it's very possible 200,000. I think there's still, especially since people don't know how this is going to play out. I think you're still going to have a lot of people that are applying that are, like you said, just it's $215. Why not apply? There's also going to be an issue of once it comes, is that you're going to have a lot of people potentially who applied but maybe did it incorrectly, so that it turns out that the actual H-1B applications are in conflict with the registrations. You know, I don't
Yeah,
know.
that's true too.
I don't
This
know.
is-
So there,
yeah,
so
we'll
there
see.
might actually, I think there's more likely going to be a second drawing this year. There wasn't a second drawing last year. I don't remember the year before, but last year there wasn't.
That's a good observation. So don't give up hope if you don't get
Yeah.
selected.
Just because you're not chosen in the first line. I want to address something, you know, because there was a question on what you said. So just to be clear on what Greg said, if things go as they are, the $100,000 fee will apply to anybody applying in the lottery if they are, you know, going to be requiring consular notification or notification of the ports.
Well, but it's only if they. Well, Ari, if well, that's true. Yes, for consular notifications for people that are filing for
right.
But the in theory,
what Greg's saying is, in theory, if they don't extend that rule, then it
or
might not apply. But right now, assume that it is going to apply to that. But you know, like what Greg's saying is that there is a
it's a $215 bet on a lottery.
Right. Exactly. So in worst case scenario, you're out $215 for the registration.
But you're already gambling because you're playing the lottery.
Right.
So you gamble a little bit more for $215. You gamble a little bit more that one of the lawsuits is going to win, or that the administration is not going to extend on time.
So yeah. So just but assuming that you know they don't forget to extend it. That $100,000 fee would apply in that scenario. Greg's not saying it wouldn't apply, but it would only not apply if the government doesn't.
What if you get selected in the lottery and you just apply for H-1B classification, and then you don't do anything with it, but it should be valid for 3 years? And in theory, we might have a new president by then. It still might be to your benefit to file and get selected.
That's true. That is true.
Just to kind of like cover yourself for when Trump is no more.
Yeah.
I want to think about it. We're already 50, you know, I don't know, 18 months.
Although again, if you're going to do it, you got to do it by 11:59 tomorrow morning.
Turn us off
Eastern time.
On there if you can.
Although we've had, since we've been saying people to turn that off and go register, there have been more people joining the call than the numbers keep going up. So no,
it's the end of the call. It's the end of the call anyway. So you still have I guess 10 hours or 12 or 16 hours to get this.
You got 15, 16 hours.
You got time. All right. We'll see you next time.
All right. Thank you. Have a great night.